and welcome to another episode of At War, the podcast by the Conflict Law Centre. Today, we are very, very happy to be joined by Victor Kattan, who is Assistant Professor in Public International Law at the University of Nottingham School of Law, where he is also the Deputy Director of the Nottingham International Law and Security Centre. Thank you so much for joining us today.
It's a pleasure to be here, Ayesha. I look forward to the discussion.
So I wanted to talk to you about the ICJ having recently given a huge landmark, people have been calling it a blockbuster advisory opinion, in which it held that Israel's occupation of Palestinian territory is unlawful and must be brought to an end. That wasn't that surprising in terms of that the ICJ would come to that conclusion, but it also said that Israel must return the land to Palestinians, it must pay reparations, evacuate its settlers, dismantle the settlements, and allow all Palestinians displaced during the occupation to return to their homes. So I wanted to ask you about a little bit of the key issues in the ICJ's opinion. So to start off with, we know that the ICJ chose not to determine whether Israel's use of force in 1967, which led to the occupation, had any legal basis at the time. And we also know that perhaps Judge Charlesworth has a big hand in this, in her separate opinion. She said this was deemed to be unnecessary, as all that matters is whether the legal basis for the use of force and the occupation is valid today. Do you think it was correct for the ICJ to sidestep this issue?
I think it was, in the sense that it would have led to probably a division on the bench, and the court's looking for consensus, to give its opinion greater authority. As you know, the events in 1967 are contested, and I've taken the view in my own scholarship that it was an act of aggression by Israel on the United Arab Republic, which was which was Egypt and Syria at the time, and Jordan. But other scholars took the view that it was an act of anticipatory self-defense. And as you probably also know in the scholarship, there's a huge debate about whether there is such a thing as anticipatory self-defense, or some scholars go further and argue for preventive self-defense. So I don't think there was a need for the court to enter that debate. It would have had to have undertaken a factual determination to revisit the documents from that period, and there are also complications about what was in the mind of did Israel feel threatened in 1967 at the time? Was there evidence to suggest that they had planned this beforehand, etc., etc.? It would be, I think, it would be an unnecessary distraction when the point is that even if it was even if we were to accept the argument, which I don't accept, if we were to accept the argument it was self-defense, it would not give Israel the right to remain in the territory for 55 or 56, how many years it's been. And in so doing, it is continuing to use armed force to maintain that occupation. And I think that's where Judge Charlesworth was coming from.
Yeah, I'm of the same opinion as you, in the sense that the court said it it left it very open when it said war broke out in 1967. But I think there have been so many memoirs now, especially from the American side, which have come out showing that Nasser had no intention of going against the Israelis at the time. I kind of did hope that they would have engaged with the meat of that a little bit.
Yeah, and there's been scholarship. I think John Quigley wrote a very comprehensive book on that. I think there's Israeli scholarships, and there's Israeli newspaper stories from the 60s and 70s in which they said that they had no, they weren't expecting an attack from Egypt. But I suppose if they're going to discuss 1967, do they have to discuss 1973? Then it gets was that lawful? So I think they needed to focus on the issue at hand, and that requires economy. You don't have to be such a long opinion as well that nobody reads it. It's quite a succinct, short opinion as well, which has a bigger punch, more effective as well.
Yeah, so in one of the really ambiguous paragraphs, the court also implied that Israel's policies of racial segregation may amount to apartheid, but seemed to shy away from an outright pronouncement of this. And I think that was similar to what the Committee on the Elimination of Racial Discrimination had said, in that it had said that there was an Article 3 violation, but hadn't specified. So despite the fact that a spate of human rights organizations have declared Israel to be an apartheid state, and many judges in their separate opinion, including Judge Tladi, the South African judge, who I thought his opinion was just the most fun to read. I think he has such nice writing style. Who had lived through apartheid, also said they did believe that Israel was committing apartheid. What do you make of this reticence to call it apartheid?
It's a really interesting question, Ayesha. I'm not quite sure why. It's not just the ICJ; it's other bodies you mentioned. CERD, I remember appearing before. So the UN Special Fact-Finding Mission on Israeli Settlements that was referenced in the advisory opinion quite extensively, which I think they reported more than 10 years ago. I actually had the pleasure of appearing before that commission, and I was a legal advisor with the Palestinians at the time, and we made an apartheid claim.
Okay.
And there were three members of the commission. I think Christine Chaney was a chair. Unity Dow was the co-chair from, I think she was from Botswana. And then the other was, I think, from Pakistan, Asma Jahangir, I think it was. And
yeah,
you know, and I could see that Asma and Unity agreed completely that, you know, they nodded their head when I mentioned the word apartheid, but the French Christine Chaney shook her head, was really upset, disagreed, and then they ended up using this phrase total segregation instead of apartheid, which has its problems of its own. So it's almost as like the word apartheid for some reason puts people off, and they prefer to come up with another descriptive label to use it. And perhaps, I mean, I can only guess because I don't know, I wasn't in the chamber when they were deliberating on this issue at the ICJ, but I can guess that might be one reason they don't like the way the word is so closely associated with South Africa. It's a word from Afrikaans. It's so closely, and it's close to it. So there's issues about, I think Judge Tladi alluded to this in his separate opinion. He said that, you know, some people seem to think it can't apply beyond the specific circumstances of South Africa. And I don't think that, of course, not everyone agrees with that, because we saw 4 other judges. I think even those that did not agree that it was apartheid, such as Judge Iwasawa, nonetheless did an analysis. I think he took an analysis of apartheid. Also, the Brazilian Judge Brandt looked at the way in which the crime is defined in the 1973 Apartheid Convention and in the Rome Statute. Even Nolte did the same kind of analysis, as did Salem, the president of the court, the Lebanese judge, and of course Judge Tladi from South Africa. So there's at least 4 or 5 of the judges who are engaging in quite a bit of depth on the apartheid issue. Now, you're right that the advisory opinion itself simply refers to Article 3, finds a breach of it, doesn't make it clear whether it's a breach of segregation or apartheid or both, and kind of makes it ambiguous. But my reading, holistically, of the entire advisory opinion is that, for me, and I've spent quite a few years now, I'm working on a book on apartheid. It reads as though it's describing an apartheid system, but without using the word. So it describes it, and they devote more space. So the main headline about the advisory opinion was the illegality of the occupation, but in fact, they spend more time discussing discrimination.
Right.
And they use this curious phrase, systemic discrimination, which doesn't appear in any of the treaties that they reference. So they reference the main human rights treaties, which all define discrimination, but they don't have that word systemic before it.
Okay.
And if you think about systemic is a word associated in international criminal law with crimes against humanity. So if you look at, for example, Article 7 of the Rome Statute of the International Criminal Law Court, it explains that what's unique about crimes against humanity is a systematic nature. What's really interesting is that the crime of apartheid is almost described as a double systemic crime, because the chapeau in Article 7 refers to systematic, as does the definition of apartheid itself. So again, for me, it looks like it's a synonym. They've used the word systemic discrimination as a synonym for apartheid. And then when we look at the constituent elements of apartheid and the customary international law, which was suggested by the judges, you have the regime, which is systematic discrimination, oppression, Then you have the inhuman acts. Then you have to show that there's the maintenance of this apartheid regime. Now, nearly all the judges agreed with the first two, that there was systematic discrimination and there were inhumane acts. Where they differed was whether the purpose of of maintaining the occupation this long was apartheid, i.e. systematic discrimination or domination, with a view to maintaining that discriminatory regime, or security. And you can see Judge Nolte taking the view that it's arguable it might have other reasons. It's not the only reasonable inference that we can take from Israel's conduct. But then Judge Tladi and some of the other judges said, no, even if it is security, that would not be a sufficient ground for discrimination, systemic discrimination, apartheid. And Judge Tladi mentioned the point that in South Africa, during apartheid, discrimination wasn't the only purpose of the regime. There were lots. There was the grand, what they called the Bantustan, the creation of black homelands. The South African government claimed that they were recognizing the right to self-determination of the different constituent nations of Southern Africa. There were economic arguments. There were cultural arguments. There were a whole host of reasons that South Africa invoked to justify its apartheid policy. There was never just one reason. And so, in my view, the court has actually, in a way, it's provided almost all the elements that you need to make an apartheid finding, but without using the word.
That's super interesting. So the bit of the advisory opinion, which is going to exercise people like me the most, is because I focus on the law of occupation, is also the fact that the ICJ kind of rubbished arguments that Gaza was not occupied since the Israeli withdrawal of 2005, which is what Israel has long been arguing about the Gaza Strip. But it seems to have also at the same time confused matters even further by stating that while the law of occupation does continue to apply in Gaza, it applies commensurate with Israel's degree of effective control over the Gaza Strip, while not stating which obligations continue to bind Israel, something which is also mentioned in Justice Cleveland's separate opinion. What do you think the court was doing here? And do you think that this is going to confuse matters even more going forward?
And again, I think similar answer to the first question that you asked. I think, again, to get consensus, they were a little bit vague on what obligations continued to apply. And I think they're also, it's interesting that they looked at Gaza at all, because I think at one point they say that they of course they had to look at Gaza prior to the recent events. But I think they didn't want to look at the recent events either, right? They made that clear that we're not looking at what's happened since October 2023. But on the other hand, they had to make it clear that the law of occupation applied to Gaza. So I think given what's happened in Gaza again, and given all the other cases taking place at the ICJ, there was probably a decision not to go into too much detail on what particular obligations apply. So they kind of made the point that it's about the capability of exercising elements of authority. So long as the government Israel still has that ability, then it remains occupied. The extent to which this is useful for other situations of occupation, you probably know perhaps more about this than I do, but perhaps one could say it's a bit unusual, the situation in the Gaza Strip, in the sense it's a very small area. It's still kept under. I mean, in 2000, following the withdrawal from Gaza, in so-called redeployment of forces from Gaza in 2005, there was of course a takeover by Hamas, and then Israel imposed a blockade, a military blockade, a land and naval maritime blockade. And declared it hostile territory, which doesn't have any status, and claimed it had a right of self-defense towards that territory. So again, I think it's for consensus. The court kind of dodged it, and that was probably wise. Again, given the nature of advisory opinions.
Yeah, I think it's also an interesting kind of acknowledgement of the rise of non-state actors and the degree of control that they can also hold. And I'm writing about this currently, so these issues are all ricocheting around in my brain. So, final question is: how do you think this advisory opinion will impact the broader international community in terms of the legal consequences that the ICJ laid out for all member states, including the role of the UN going forward in addressing the Israel-Palestine conflict?
Yeah, it's interesting. So I saw, I think, on social media there the draft resolution, draft UN resolution that's been circulated by the Arab group at the UN, and it appears pretty comprehensive, kind of reiterating some of the language, but also going into detail about sanctioning individuals, authorities, institutions that deal with the occupied territories. There's a very vague reference to the UN Special Committee, a UN Special Committee to review breaches of Article 3 of CERD on segregation and apartheid. But and so on the language, it looks pretty powerful. But my concern is there's no implementing body. So it's a General Assembly resolution. So as you know, it's not binding, but nonetheless, it could galvanize and give an impetus for those states that want to act effectively unilaterally, because we're not going to get anything from the UN Security Council to do so, which is what happened in South Africa, by the way. The movement began outside the UN Security Council. It began in the UNGA and by states breaking off diplomatic relations with South Africa and then implementing their own kind of trade embargoes and the like. So I think from what I've seen, and the draft resolution may change, it looks like a very robust resolution. The Israelis are already complaining that if the resolution is passed, they're going to dismantle the Palestinian Authority. My main concern is it would be good to have established a body to oversee the implementation, to see which states are actually following the resolution, even if it's just recommended. You could name and shame them, for instance, if they don't follow through on it. So I think it's a bit vague. It could be improved, but it's a far better resolution than the one that they had adopted 20 years ago, following the previous advisory opinion on the construction of the wall separation barrier. So it remains to be seen, because it's a live issue. We don't know how. It'll be interesting to see how many states vote in favor of the resolution. I'm suspecting there'll be a north-south divide. Global South will support it. The European and the Western states won't. But we don't know. There may be a few that buck that trend. I'm given, and also what's intriguing about this advisory opinion is a political context, given the war in the ongoing conflict in Gaza and other parts of the world, but of course in Gaza, in southern Lebanon, and elsewhere, which has made it a real live issue. I mean, you wonder if this would be how states would react to this advisory opinion if there had been no conflict in Gaza at all. I think what Gaza has done is drawn the world's attention once again back to this conflict, increasing public awareness and interest in why this conflict is perpetual, never ending, and one hopes that people will learn more about what's going on and will come up with new ideas to resolve it.
Yeah, and I think given how long it's been, and I think for so many people who I speak to regularly, they're like, this is the first time I'm reading books about Israel-Palestine. So I think in terms of educative impact, it's really had that. But also the Global South has been a huge galvanizing impact. I mean, just seeing South African lawyers take Israel to task for genocide was momentous. And Nicaragua also tried to do the same with Germany, but we hadn't seen that momentum before coming from Global South in terms of using international fora. So I think it's been quite huge in that respect.
Absolutely. I couldn't agree with you more, Ayesha.
Thank you so much for joining us today.
Thank you. It's been a pleasure. Pleasure to be on your program.
And thank you so much for everyone for joining us at home.